Welcome, 1Ls. Okay, so if you're deep in the trenches of your first-year law studies and staring down the barrel of your contracts final, you are in exactly the right place. Today, we're cracking the code on two of the absolute most heavily tested and, frankly, most misunderstood topics in contract law: anticipatory repudiation and adequate assurances. We're going to distill textbook sections 9.05 and 9.06 into a totally actionable, exam-ready explainer so you can walk into that final with total confidence. So let's dive right in. Picture this. You sign a contract, and the performance isn't due for another month. But suddenly your counterparty sends you an email hinting that they might not be able to pull it off. What do? Do you really have to just sit there, wasting time and money, waiting for the actual deadline to pass before you can sue them? Or can you pull the plug right now? That is the exact dilemma your law professor is going to test you on. Here's our survival guide agenda for today. 1. Defining anticipatory repudiation. 2. The foundational Hochster case. 3. Curable defects in the Cohen case. 4. Adequate assurances. 5. The Dre case malpractice trap. And 6. Your 1L exam action plan. Let's do this. Section 1. What exactly is anticipatory repudiation? Let's break down Section 9.05. Anticipatory repudiation basically occurs when a party renounces its duty before the time fixed for performance. But listen, here is your absolute golden rule for the exam. It requires a definite and unequivocal manifestation of intent not to perform. Seriously, write that phrase down. It can't just be a mere expression of doubt. Plus, the threat and breach has to be material. If someone definitely and unequivocally tells you they're going to commit a material breach, the law says you don't have to wait. You can suspend your own performance and bring in immediate action to recover damages for a total breach. Section 2. The origin. We're looking at the foundational 1853 English case, Hochster v. de la Tour. The facts here are a classic exam pattern. So back in April of 1852, the defendant hired the plaintiff to act as a courier for a European tour. The service was scheduled to start on June 1st. But on May 11th, the defendant wrote to the plaintiff explicitly stating he'd changed his mind and the courier services were no longer required. The plaintiff didn't just sit around, he immediately sued on May 22nd. And this brilliantly illustrates the core logic of the entire doctrine. Just look at the timeline. Before 1853, the courier would have been legally forced to remain idle, buy his travel gear, and wait until June 1st to sue, passing up other job opportunities in the meantime. Lord Campbell recognized how crazy that was. By allowing the lawsuit on May 22nd, the court established that once a contract is completely renounced, the innocent party is instantly absolved from future performance. This lets the injured party go find alternative employment, which actually mitigates the damages the breaching party ultimately has to pay. It's basically a win-win for economic efficiency. Section 3. Curable defects. Let's look at Cohen v. Kranz from 1963. Okay, in this case, the plaintiff contracted to buy the defendant's house for $40,000 and put down a $4,000 deposit. The closing was set for December 15th. Well, on November 30th, the buyer's attorney sends this super aggressive letter stating the structure was illegal and the title unmarketable, demanding the deposit back within 5 days. The problem? The supposed defects were literally just a swimming pool lacking a certificate of occupancy and a split rail fence projecting a tiny bit past the property line. Both of these were entirely minor and super easy to fix. So, the absolutely crucial point here is understanding the difference between curable and incurable defects. If a seller has an incurable title defect, they're automatically in default, and the buyer doesn't have to make some idle gesture of tendering performance. But, and guys, this is a massive trap for 1Ls. If the defects are curable, the buyer must formally tender performance and demand a good title deed to put the seller in default. The law actually grants sellers a reasonable time beyond the closing date to clear minor hurdles. Because the buyer and Cohen sent an advance rejection without spelling out the exact defects, she prevented the sellers from ever having a chance to cure them. The court ruled that her premature rejection was, in itself, an unjustified anticipatory breach. Crazy, right? She didn't just lose her $4,000 deposit, she actually opened herself up to liability for the seller's damages. The big takeaway here: do not cry breach over fixable problems without giving the other side a fair chance to fix them. Section 4. Insecurity and adequate assurances. We are venturing into the gray areas of Section 9.06. You know how it is. Sometimes you hear rumors. Maybe your buyer's financial situation is looking incredibly shaky, or they say something vague like, well, I'm not sure if we can get the materials. It falls short of a definite and unequivocal repudiation. This is known as a prospective inability to perform. If you suspend your performance too early, guess what? You are the one in breach. But if you just keep performing, you might be pouring money down the drain into a doomed contract. Thankfully, the law gives us an escape hatch. Under UCC Section 2609, if you have reasonable grounds for insecurity, you follow these exact steps. First, you must have reasonable grounds, not just paranoia, but something real based on commercial standards. Second, you can commercially reasonably suspend your own performance. Third, you must demand adequate assurance of due performance. Fourth, you wait. And fifth, if they fail to provide those assurances within a reasonable time, then and only then can you legally treat their silence as a full anticipatory repudiation. Now pay super close attention to this distinction because your professor will absolutely test it. If your exam fact pattern is about the sale of goods, you're under the UCC. UCC 2-609 explicitly requires the demand for assurances to be in writing and strictly caps the waiting period at a maximum of 30 days. However, if you're dealing with a real estate or services contract, you apply the common law under Restatement Section 251. The restatement is way more flexible, it doesn't strictly demand a writing, and the time limit is simply a reasonable time based on the circumstances. Spotting which rule applies is totally key to getting full points. Section 5. The Malpractice Trap. A cautionary tale called Drake v. Wickwire. All right, so attorney Tom Wickwire represented a seller, Drake, in a land sale. The contract required closing ASAP. On April 11th, Wickwire called the buyer's broker to set up the closing. The broker basically said the buyers couldn't close that day because they didn't have the cash yet and might need until May 1st. Based solely on this one phone call, Wickwire immediately advised his client to cancel the sale and sell the property to someone else the very next day. But check out this smoking gun quote from that fateful phone call. When Wickwire pressed the broker on whether the buyers lacked the down payment entirely, the broker replied that the buyers in fact had the money, but were just resisting the pressure to close. Think about our rule from earlier. Does resisting the pressure to close on a specific arbitrary date sound like a definite and unequivocal manifestation of intent not to perform the contract at all? The court said absolutely not. It was completely ambiguous. Because the statement was so ambiguous, Wickwire was actually found negligent as a matter of law. He advised precipitate, reckless conduct. What he should have done, according to the court, was used Restatement Section 251. He had reasonable grounds for insecurity, sure, so he should have formally demanded adequate assurances of performance from the buyers. By jumping straight to canceling the contract, he literally caused his own client to be the breaching party. It's a harsh lesson, for sure, but a perfectly tailored exam scenario. Section 6. The 1L Exam Action Plan. Let's get you ready to master your finals. All right, here's your explicit issue spotting checklist. When you read that fact pattern, you need to ask yourself, first, is the threat definite and unequivocal, like we saw in Hotchter, or is it kind of ambiguous, like in Drake? Second, would the anticipated breach actually be material? Third, what universe are we in here? Common law or UCC? That dictates your exact rules for assurances. Fourth, if someone is rejecting performance, are the defects curable, like the fence in Cohen? If they are, they got to tender performance first. And finally, if it's a gray area, did the aggrieved party demand adequate assurances properly before pulling the plug? If you systematically apply this checklist, you won't fall into the traps that caught the buyers in Cohen or the attorney in Drake. You now have the exact tools to analyze pre-performance issues like a seasoned pro. So, I'll leave you with this. When you sit down for that contracts final and the fact pattern throws a panicking buyer or a flaky seller at you, are you going to patiently wait for the deadline, or will you spot the definite and unequivocal repudiation and score those top points? Good luck with your studies, keep this framework in your back pocket, and you are absolutely going to crush it.